she will be,
This meeting is being recorded.
thank you very much. So this meeting is being recorded and staff will capture the feedback. So we really ask that you place your questions that you may have in the chat so that we can capture those. You can also raise your hand if you need to, and we can see if we can unmute you, but please place your questions in the chat. And we will also provide you a PDF copy of the materials today. So thank you very much. Next, I would like to introduce Judge Chess, and Judge Chess will has the next portion of this presentation. Judge Chess?
Thank you, Victoria. So what is probation at Seattle Municipal Court, or otherwise known as SMC? Probation is a post-adjudication or post-trial case management program. Many cases in the Seattle Municipal Court never come to probation. The case might get dismissed or resolved in some other way that does not involve probation as part of the sentence. If a person is found guilty of a crime, then they might be assigned to probation as part of their sentence. At sentencing, a judge may order several obligations for a person to complete. These obligations are often negotiated through agreed orders or plea agreements between the city attorney, the defense attorney, and their client. For example, someone who has committed a domestic violence offense may agree to participate in a domestic violence intervention program that includes treatment. Probation staff rarely weigh in on what the sentencing obligation should be. The probation counselor's role is to support a client in successful completion of court order obligations, help them achieve self-identified goals, and with the goal of transitioning them out of the criminal legal system. Now, how do people get to probation? Well, cases eventually referred to probation start out like any other criminal cases. So we've got this diagram here that you can look at. First, there is contact between a person and the Seattle Police Department. Once that contact happens and the Seattle Police Department believes a crime has been committed, then they refer the charges, because there may be several behaviors that they feel has violated the law, to the city attorney. It is the city attorney who makes the filing decision. And once that decision is made, the case is filed with SMC and then heard in court. If this case progresses to the person being found guilty or entering a plea of guilty, then the court will sentence, and that's when we call enters a disposition. At that point in the sentencing process, a judge may decide that a person should be referred to probation. Next slide. So conditions of probation. This is like, what does probation really look like at this point? Again, we have to remember that the case resolution is oftentimes negotiated between the prosecution and defense and with the agreement of the client. I really want to emphasize to let you know is that the judge does not always have to follow the recommendation. For those of us who have gone over the plea form, there's this section that says to the defendant, you do understand that the judge does not have to follow the sentencing recommendation of either the city or your own attorney. So at the sentencing, as I mentioned earlier, the judge may impose conditions. Not all cases with conditions are referred to probation. Usually it's the cases where there's active conditions. And so you might say to yourself, well, what are those active conditions? What could they look like? So typically what we see are conditions that could include substance use disorder evaluation and treatment. In other words, we are asking that individual to get an evaluation and follow treatment, or mental health evaluation and follow-up treatment, the domestic violence intervention program, which is called for short DVIP, attend DUI victims panel, or perhaps having to get an ignition interlock device installed on their vehicle. And that's just a short list. There could be other things, But basically, it's something that a person has to get involved with after the sentencing is over, that we'd like to have the probation counselor give them guidance and help to ensure that they meet those conditions. Next slide. So why probation evolution? There's been a palpable transformation in the air at the Seattle Municipal Courthouse these days. The often-strained relationship between probation counselors and their clients is softening into something far more cooperative and less adversarial. I'm seeing less of an adversarial relationship between probation counselors and clients who seem less agitated. Probation counselors are showing more empathy with a calmer demeanor. This sea change also extends to the courtroom, fostering a more collaborative environment. During review hearings, probation counselors are presenting their work with a confidence that no longer feels defensive. I credit much of this development to the probation department's commitment to instilling the principles of trauma-informed care in its staff, otherwise known as TIC. As a result of the courtroom dynamics are shifting, with probation's focus on trauma-informed care influence not only the client-counselor relationship, but also the broader court culture. And I just want to kind of give some shout out to these words is that for most of us who have been working with people who have trauma, we realize that trauma comes early in their lives. So by the time they arrive to our courthouse, there have been years and layers of trauma that needs to be seen and addressed. So my vision during my tenure as presiding judge revolves around enhancing diversity, equity, and inclusion, as better known as DEI practice. This involves increasing our understanding and developing skills in the realms of traumas, impacts by learning and develop competency in the impacts of trauma. By ensuring everyone, be it court staff or my colleagues on the bench, always consider the prior trauma of clients and others who have business in this court when serving them. I believe we can create a more equitable justice system. Since 2021, probation has dedicated resources to enhancing competency in 3 critical areas: harm reduction, motivational interviewing, and trauma-informed care. Over the past couple of years, probation staff who work with clients have completed more than 15 hours. Let me repeat that again. 15 hours of direct TIC training, a testimony to their dedication and commitment to this new approach. Probation is leading the way for the court to become more supportive, collaborative, and equitable place, a beacon of positive change within our criminal justice system. So with that, I'm going to turn it over to my colleague, Jason Grant.
Thank you, Your Honor. Appreciate those words, and thank you all for joining us today on your lunch. My name is Jason Grant, and I am the manager of probation services here at Seattle Municipal Court, and I'm going to walk you through some of the nuts and bolts of our evolution project that's been going on for the past year and a half or so. I think it's important to sort of call out, what this project was guided by and what initiated it. I think it would be safe to say that the practice of probation monitoring is always evolving. We're always looking to do better. But this particular project is largely guided by the evaluative reports from the Bureau Institute of Justice and the Seattle Office of the City Auditor. Both those reports are available for public viewing on our website. And if folks can't locate those, we're happy to, if you want to email or message that you'd like a copy, we'll be happy to forward those to you. It's important that those are available for you to view, and it gives great context for what we're talking about today. In addition to those reports that really guided a lot of our decisions and the next steps, we used the Seattle Race and Social Justice Toolkit to help guide our efforts. And we worked really, really hard to engage our community throughout the process. We involved community partners, past and present probation clients, other interested parties, treatment providers, through surveys, webinars, feedback sessions. Yeah, and in so doing, we gained a wealth of knowledge, input, and feedback on different perspectives and insights on, what really we need to be pushing for with respect to how we do our work. What we also hope that came from that work was a strengthened reputation within our community, enhanced relationships with our partners, with other folks that are involved with the clients that we serve, and most importantly, an overall impact in a positive way for the clients that we work with in achieving positive, equitable outcomes as they come through the probation system. Next slide. So both reports gave a series of recommendations on how substantive changes that they believed our department should work towards making or deploying. We're proud to say that of the 15 VERA recommendations, 93% or 14 out of the 15 have been completed. And of the 14 city auditor recommendations, 86% or 12 of them have been completed. The remaining items in those reports that are still being worked on are not related to direct probation practice and more geared towards court policies and approaches as a whole, and that work is ongoing. So, high level, kind of what did we seek to emphasize, and what changes did we make in this past year and a half of work? We sought to create more equitable assessment guidelines, replacing our risk assessment tool, which was antiquated and was shown in multiple reports to have disproportionate impacts on BIPOC communities, with a more equitable assessment or evaluative tool in determining how clients report to us. We've standardized our case management process. We worked towards a client-focused planning and quarterly report process where we are transparently showing how decisions are made with respect to probation status, and also working with clients to determine what their needs are, and that being just as much of a part of our work in probation as the conditions that the court imposed. We've updated our non-compliance policy, separating non-compliance into technical and substantive categories to keep as many people out of court as possible, while always still addressing those non-compliant concerns. And then we've increased our training requirements of staff. So expanding probation counselor training to include, like Judge Chess mentioned, harm reduction, motivational interviewing, trauma-informed care, and equity to action. I think it's really important, and again, to echo on Judge Chess, is what we're really seeing is that the courtroom dynamics are shifting, and probation counselors' focus really is moving to a more supportive, trauma-informed approach. Tackling that first box, risk assessment tool replaced with a new, more equitable guidelines. Clients referred to probation now automatically report in person on a monthly basis during phase one. Phase one is a 3-month period of time designed for us to get to know the client, onboard them with the responsibilities that the court has asked of them, but also case plan and figure out what they need and what services they'll benefit from on a voluntary basis, not necessarily related to what the court has asked them to do. So that's the first 3 months of the referral. When clients complete benchmarks during phase one, they move to phase two. Their reporting requirement moves from a in-person requirement to a virtual or phone requirement for the next or the subsequent 3 months. When clients stay on track during phase two for 3 months, if they're following through with what the court has required and they're stable, then they're no longer required to report to a probation counselor for the remainder of their time on probation, as long as they continue to follow through with their treatment responsibilities. So what we hope is that, in terms of expected benefits, is that we ensure that all clients have equal opportunity to a limited number of meetings with probation, and only meetings that are necessary to helping them accomplish what the court's imposed. And clients who show with support that they can follow what's been asked of them are also showing the court and the probation department that they no longer need the support of a probation counselor to follow through with what's expected of them. This gives really, probation counselors more time to spend on those clients who are struggling. So, one of the things that's really important to remember is it's also a mechanism to focus our attention on those clients that really need our help, and give those that can handle those responsibilities the space that they've earned to follow through on their own. Case management is standardized with client-focused planning, case planning, and quarterly progress reports. So we recognize that case management practices historically were not always consistently applied across the department, and often included discretionary decision-making points that were prone to inequitable practice. So we work to update our policies and procedures based on best practice, community feedback, recommendations from the VERA report, to include, case planning, transparent, frequent progress reports that are visible to those that are involved in the case, and regular quality assurance and review of probation counselors' work. So clients now work with probation counselors to build personalized case plans. That includes not just what the courts ask them to do, but any personal goals and needs that they need to improve their life and end up in a better place than they were when they started with us. So by doing so, clients and counselors, can identify, what areas of personal, struggles or needs they have. And that allows probation counselors, to better understand the underlying issues they have, that they might be driving those behaviors that get them involved in the criminal legal system to begin with. And it also connects clients with, those valuable resources and services that may help as well. So client case plans are reviewed at every monthly check-in. We're always circling back on what we've identified in that case plan. And we want to make sure that each time they connect with a probation counselor, there's value to it. It's worth something. And the client comes away from that interaction with a substantive conversation about not just what they're supposed to do, but what they want to do and what they identify as something they need to work on, or support they need, or services they need. And we want those interactions every time to be valuable and worth their time, because their time's valuable too. It's also important to note too that, on the case plan, in those areas of personal needs and the things that the counselor works with, to support the client, those aren't compulsory. Those aren't required. That's client driven. We'll support them and do everything we can to help get them to where they want to be. If they choose not to follow through with what they've identified as a need or a goal, that doesn't make them non-compliant with probation. It just means that, they're not ready, and we'll continue to support them at the cadence that they ask for our support. Counselors complete quarterly reports. We call them phase reviews, that show a client's current reporting phase. So whether it's phase 1, phase 2, or 3, and their accomplishments, any barriers they have if they're not being reduced from, let's say, in-person reporting to virtual reporting. Why is that? What's holding them back from being successful in what the courts ask them to do and what we're asking them to do? And then how are we helping them with those barriers? That's designed to be transparent. So anybody that's involved in the case at any time can look in the court file and see what's holding this client back, or conversely, how they're doing and where they're finding success, and sometimes both. So preparing these reports and submitting them to the court portal is an expectation, and it allows defense attorneys, prosecutors, judges to always have a clear picture of the client's journey through their time on probation. Next slide. Thank you. Our non-compliance policy has been revamped. We historically, our non-compliance policy requires staff to schedule court hearings, as soon as possible for most violations. And after reviewing that, informed by the VEER report, informed by community feedback, informed by staff feedback, and even internal court partner feedback, and looking at it from an equity lens, it was determined that this approach really has a super high probability of inequity and disproportionately impacting some clients. And I think one of the things that we have to emphasize is, under all of this work, what we're trying to strive for is not only equitable outcomes, but equitable practice and application of policy. And this new policy really separates non-compliance into two categories, technical and substantive. And one of the big goals of this is that, work really to keep clients out of court, especially on the technical side. And we'll get into kind of what that means here at the next slide. So technical and substantive, what does that mean? Technical non-compliance is usually related to programming and a client's follow through with an evaluation or treatment or a class. It can also mean, reporting to probation. It also means, positive drug tests. It's behavior that doesn't constitute in and of itself a criminal offense. It's technical. It's a condition of probation. Substantive is, oftentimes a little bit more concerning. It's new criminal behavior. It's an alcohol-related ignition interlock violation where there's evidence or that a client might be attempting to drive after a while under the influence. It's substantiated victim contact. A person is violating someone who has a protective order in place. And it's deferred prosecution violations that are, largely guided by a statutory response for non-compliance. Technical non-compliance in and of itself does not immediately require court intervention. Probation counselors, if it's isolated behavior, can address that violation during monthly check-ins. They can ask the client, what's going on? How can we help you? The sky isn't falling. Let's get you back on track. Identifying what those barriers are and trying to offer them support and services to mitigate whatever is going on that's preventing them from complying with what services they're engaged in or reporting. Sustained technical non-compliance. So, you have a pattern of non-compliance with reporting or treatment does lead to a scheduling of a hearing. However, probation counselors now are authorized to cancel review hearings when through more support, more contact with the client, they're able to get that client back on track before the hearing takes place. We call those CPIs, case plan interventions, and it's really it's a plan that the counselor puts on their own calendar to give the client more support and more collaborative engagement with the treatment provider if the client's in treatment. Substantive non-compliance usually relates to, like I said, continued offense behavior. It does require a hearing. It can't be canceled. It needs to be addressed by the judge. And those hearings are set upon the availability of the court calendar. Okay, so increased training requirements for counselors. We touched on this before. Are always looking to provide equitable, personalized responses for different situations. Due to our own known biases and how we interact with clients. Our emphasis has been, throughout all these policy and procedural changes, that we root that work in a few really important areas, and that's, again, and Judge Chess touched on it: trauma-informed care, harm reduction, motivational interviewing. So in adopting those new training requirements and putting counselors through quite a bit of training in the last year and a half, we've committed to those principles, not just as an isolated class that they take, but an ongoing commitment not just for existing counselors, but new counselors as they come on board. This needs to be a regular part of how we train staff so that we are always connected to those principles in some way or another, especially on the trauma-informed care side. I don't think I need to tell anyone how important it is that we always recognize the story that a client brings with them when they come across our desk, the struggles that they're going through, and that always needs to inform how we interact with them, how we treat them, and how we approach our case management and our responsivity. One of the other trainings that was provided to staff and is a bit of a work in progress right now is working with women in the justice system. One of the things that came out of the Vera report was that the outcomes for the women that come to our office are disproportionately negative with respect to outcomes, and it was really important that we put an emphasis on training and understanding how women go through the criminal justice system, the challenges they have in complying with traditional programming that isn't always the best fit for them. So we partnered with Family Peace Initiative. It's an agency in Topeka, Kansas. And it teaches that, to motivate change and growth with clients, there needs to be, an identification and acknowledgement of those past traumas and how they're impacting, clients' current behavior and their likelihood of success. So this is a 5-hour training. We hope that, we feel that probation counselors have really enhanced our understanding of those experiences. Currently, we have one probation counselor at SMC who's pretty much fully responsible for supporting women who have entered the criminal legal system. And we're currently exploring what it would look like to add at least an additional probation counselor to do similar work. So what our data is telling us throughout all of this work, what's also been going on is how do we measure? It's one thing to create policies and procedures that we believe are more equitable. It's another thing to measure that work and the outcomes of that work to see if the outcomes are making the outcomes more equitable as well. So our data at this point, is we're looking at active caseload, case status, time measures, overall probation case outcome rate for 2021 to second quarter 2023. 64% have completed all their conditions and obligations. 15% have been revoked and 20% stricken for administrative reasons, which is typically means there's no penalty or consequence to close. The court has just closed their case prior to jurisdiction end date. When we look at reporting levels, we know that all clients referred to probation start at what we call phase 1, in-person reporting. Over half of all of our probation clients now who are past their 90-day phase review are in level 2 or level 3. So they're no longer having to report in person to probation. When we look at activities and compliance, probation activities are predominantly treatment related now. The requirements are related to treatment. The number of probation activities, the things that show up that are imposed or are conditions of a client's activity in the community has fallen from where it was in 6.8 in 2017 to 3.3 per client and at the end of 2022. So we look at adverse outcomes. The number of review hearings for probation is on pace to be 30% less in 2023 than it was in 2021. From 2021 to Q2 2023, that 120 unique individuals were directed back to jail due to probation revocation. Half of those individuals were on domestic violence, or in the domestic violence. So that I'm not sure what the comparing number is to prior years, but if you look at the course of over 2 years, 120 is while we'd always like to get it lower, is a number I know is much smaller than it was 5-6 years ago. All of that information can also be broken down by race, gender, and age. And it's accessible, and I'll get to this in a second. It's accessible for the public, for each of you to view on our public dashboards. So where do you find those? Good question, glad you asked. If you go to seattle.gov/courts and you select about, you'll see a navigation pane. It says probation data reports. And from there, you will see the links to the various data points that I just discussed. Those are always being updated. And so they usually represent real-time data. And I think at a minimum, they are updated quarterly. So they are usually fairly representative of what's going on with probation clients in that moment.
Thank you. Thank you. Thank you. Some folks have asked if they can have a copy of the presentation. So at the end, we'll place a PDF in the, provide you access to the PDF. The other way is please communicate through the Q&A chat. And at the end, we have a video and then an opportunity also for you to ask questions, okay? So part of this slide is all about good news, and the probation counselors are transforming the program. I was able to interview 4 individuals who were going through the new probation process. And my heart was just really warmed by their response in the questions. For example, 2 that had gone through the system before, and 1 who was going through another city's system. But what one person said was, I felt seen, I felt heard, I felt like I had someone who was on my team. Another person said that while they were in there for one thing and the court had said they needed to go through drug and alcohol, they also had the opportunity to learn that they also had some, that mental health should also be part of their healing and what they were going through. And so they said it just has made a world of a difference to them. And so just listening to their stories were just so heartwarming. So the training that the probation counselors are going through, the new process and procedures. Judge Chess talked about the difference in the courtroom dynamics and how they're shifting, and then how we're using data to help us track, and also we'll be able to evaluate what's happening. And so using that data to see where there might need to be additional changes in the process or the system. And so when you get the PDF, you'll be able to link onto some of those articles that we have published regarding that. And the next slide is just a compilation of some of the wonderful quotes that I pulled from. So you heard from Judge Chess, but you know, some of them, like I have direction, structure, and I'm not left alone to my own devices, direction and insights. I have someone to talk to about my achievements. Or I had a lot of trouble the old way. This time it's easier to get things done, and I feel like I want to get things done. I have someone who is supportive. And so it just really warmed my heart talking to individuals, and as they're going through this process, you know, or they talked about the old process or the process that other cities are doing, and how they just felt like they were just a number, and they just were trying to figure out and navigate, and they were struggling. So kudos to this to probation and to Seattle Municipal Court on doing this work. So moving forward, as I said, monitoring performance measures. You know, we want to understand where the disproportionate impacts may remain, and so we're looking at the data. We're looking at the information. Make data-informed changes, share performance metrics and dashboards with community interested parties. So that's what we're doing. And Jason just shared where you can find that information. And then continue to involve interested parties in the decision-making process, and continue to expand the trainings and provide trauma-informed care for our staff, for all staff. So as we look at it across the court, where else might we also provide this training? Next, the next coming up, we have a video. It's a quick 4-minute video. And then after the video, we'll have an opportunity for you to get to your questions. And then we'll talk about ongoing ways to stay engaged. So this video that you're about to see, we heard feedback from our clients and our customers and our community that, people may not understand how to navigate this new probation process, and trying to navigate it. And one of the best ways to communicate to people, even especially if there's language barriers, and this will be translated in additional languages, but also individuals understanding and reading and comprehension. So we put together this video, and we'd like to share it, and it will be on online as well. So Christina?
This video on probation services will describe what a client can expect during their time on probation, including meeting with their probation counselor and the phases of probation. Seattle Municipal Court does not use probation officers. Instead, we use probation counselors who help their clients access services and provide support. Probation counselors also report back to the court on how their clients are doing on probation. Clients can be referred to probation by a judge in criminal cases where a sentence or other court action has been imposed. Once a person is referred to probation, they will attend scheduled meetings with their probation counselor. During these meetings, a probation counselor works with their client to understand their current situation, background, barriers, and needs. If the client is a non-English speaker, interpreters will be available. The probation counselor will also cover the court order requirements, like how to check in and communicate with a probation counselor, the case plan, and the phases of probation. Court order requirements are the things a client must do while on probation. Following these requirements is called being in compliance. A case plan is a document that details both the client's probation requirements and their personal goals and needs. Case plans guide and focus counselor and client interactions towards a successful outcome. Case plans take into account issues such as substance abuse, mental illness, homelessness, and access to basic human needs. There are 3 phases of probation. Each phase has a 90-day mandatory period before a client can move to the next phase. Clients move from phase to phase by staying in compliance. In phase 1, clients meet in person once a month with their probation counselor for the first 90 days. These meetings can take up to an hour. After 90 days, the client will move to phase 2 if they remain in compliance, such as meeting with the probation counselor when scheduled, following through with required classes or programs, and avoiding new criminal law violations. In phase 2, the monthly meetings move from in-person to virtually or by phone if a virtual meeting is not possible. After 90 days in phase 2, the client will move to phase 3 if they remain in compliance. In phase 3, the client is no longer required to meet with the probation counselor, but they are still required to continue with all other probation requirements. If a client falls out of compliance in any phase, they may be subject to more meetings and case management by their probation counselor, review hearings where the judge addresses the compliance concern, and return to, restarting, or staying in phase 1. While any form of non-compliance can impact probation, major violations such as new criminal law violations, alcohol-related ignition interlock device violations, and prohibited victim contact will result in hearing with a judge and may return the client to phase 1. Our goal is to support clients to complete probation and develop the life skills and community support necessary for lifelong success. A resource hub within the courthouse called the Community Resource Center offers connections to services that address personal challenges that interfere with a client's success. For more information about probation, visit the probation webpage at seattle.gov/courts/probation or call customer service at 206-684-7840. Thank you.
Thank you. Okay, so next we have the opportunity for questions. So there are some questions in the chat. I'm trying to see if, Jason, can you also see the chat? What's in the chat? The Q&A, I mean the Q&A. Let me see here. I can pull these up. Okay, let me see if I can pull them all up as they're coming in. Okay, so I see, okay, Lisa had to leave, and so she just wanted to say she had to depart for another meeting, and it's really impressive work. Thank you for it, and thanks for sharing. And Julie had in the Q&A that she would love to see more victims of crime involved in your community feedback. I'm very glad that you are recognizing prior trauma and barriers your clients have. However, the clients most likely are either DV abusers or have substance abusers. Those clients are more likely to be dishonest about their actions. I don't always see the court acknowledging this. How does this probation supportive environment account for that? That lack of accountability is the frustration I hear from most victims. So.
Yeah, I think that's a great question, Julie, and thanks for asking it. You know, and I'll do my best to answer. I will say that, you know, in those situations, the relationship that we have with treatment providers and the advocate's office is critical. Our interactions with the client is monthly, and it can be an hour once a month, and sometimes more, but for the most part, it's limited to you know, to that standard. When a client enters services and they enter treatment, the folks that see that client the most are those that are offering direct client service and treatment. And so our relationship and our collaboration with them is critical so that we can be responsive to non-compliance or behaviors that rise to the level of victim safety concerns. And we know that your office has regular contact with clients or with victims. You know, that relationship is critical as well. Probation counselors, especially at the misdemeanor level, largely rely on those relationships and the communication with those that see their clients more than they do. So, and then are in turn responsive to that. There is not a scenario in our policies or procedures that doesn't allow us to be responsive to victim safety concerns or behavior that puts the client in non-compliance with what the court's asked them to do. But we rely on that communication, those relationships to be informed and then take action.
Thank you. Okay, any additional questions? Place it in the Q&A. Okay. There's another question. Once a case has been set for review of non-compliance, who determines what probation phase, if any, that a client will return to?
It's not who, it's what. That's not a discretionary decision. It's a great question. Our policies guide what phase a client is in. And there are certain violations that would automatically return a client to phase one. For example, a client that's on under the court's jurisdiction for an impaired driving case. And let's say they've done well in treatment, but they've incurred a new DUI related offense. Because they reoffended in that similar offense type, they would, by policy, be moved to phase one. If a client is in a reduced phase and they are in technical non-compliance and they end up going to court because the counselor wasn't able to support them and they weren't able to regain compliance by the time they go to court, that returns a client to phase one as well by policy, not by decision. And so it's, you know, it's all of our phase decisions are guided by a policy framework and that are not discretionary. That is one of the big things that we really sought to use to achieve equity in practice, so that those decisions that truly impact a client's life are guided by a system that we hope is equitable.
Thank you. Okay, we have another question here, and I don't want to put Mark on the spot, but Mark is our Deputy Court Administrator in Operations, and there's a question. And let's see here. Do you anticipate the Community Resource Center will offer more days, time, availability, given this new approach? I recently saw that they are closing on Thursday for the time being.
Thanks, Victoria. Yeah, the CRC right now, we are having staffing challenges with some staff who supported that project who have moved on to other organizations. So we are right now assessing the CRC and what is feasible for us to offer. So right now I can't give a specific answer other than to let you know that we have a work team working on looking at the CRC so that we can make some decisions about what is feasible and what we can offer going forward. So stay tuned, hopefully soon, for some more information about that.
Thank you, Mark. Okay, any other questions? Okay. I don't see any additional questions. And so let's see here. So we will go to the next slide. And that is how you can stay connected. So in the PDF, you'll be able to click on these links as well. We'd love for you to stay connected. We are soon, we will be inviting interested parties to be part of the conversation around pretrial services. So keep that in mind. So sometime in the near future, we'll be reaching out to people to see if they're interested in a conversation with us regarding pretrial services. Next slide. I would like to end this session with just hearing the voice of Judge Chess, our leader, as she reads to us the commitment that Seattle Municipal Court made in the Vera report. Judge Chess?
Thank you, Victoria. I'd like to thank everyone who came. And even if you didn't get to see it to the very end, I hope you get the video and that you go back over this information. So I'd like to end this session with talking about commitment. Our nation's criminal legal system has had a long, painful history of racial injustice and structural racism. Is still apparent today in courts across the country, including Seattle Municipal Court. Though our court is only one piece of a larger criminal legal system, we are committed to equitably serving the people we work with, eliminating racial disparity in all of our work, and engaging with our partners to create change in the system as a whole. Again, thank you for joining us. And if you know some people who weren't able to attend but want to learn more about what we are doing here at Seattle Municipal Court, please forward them the information. And we hope to be continuing conversations like this in the future about all the things that are happening at Seattle Municipal Court.
Thank you all. Take care. Have a wonderful weekend.